And I wanted to go over the agreement to list your property. And again, this agreement is between you and Carla and Posted Realty. The beginning date I have listed is October the 1st. That's like Thursday before the weekend where we're going to do the open house. We don't necessarily have to have people coming in the house at that point, but we can make sure that it's published and it's out there and everybody's had an opportunity to see that it's coming up over the weekend and then go ahead and schedule showings. So it gets as much exposure as it can as quickly as possible. And then ending on March the 1st, we usually put that 6 months out. That's plenty of time usually to get the home sold. And if it doesn't sell by then we need to do some adjusting, I think. The rest of it is just the particulars on the property, and really nothing as far as real estate described, anything else that's attached there. In the previous video that I had sent you, it discusses the agency agreements. In this particular case, I'm going to recommend that you check on the box that says permission to act as a dual agent may be considered at the time I am provided with information about the other party to the transaction. And also you can click on permission to act as a designated agent may be considered at the time I am provided with information about the other party. Probably the designated agent would be the one that I would select, but you can check the other one if it should come up where somebody would call me and really want to negotiate with me and you on the sale of the house. You have the opportunity to say no to that at that time. So totally up to you, but I would suggest those two being checked as if it arises, we will discuss it and then we can determine whether or not we want to move forward with that. You'll also be initialing here where it says you've acknowledged that I have gone over these explanations with you previously. We're going to list at $374 as you have requested, and again the 6% of the sales price will go as commission toward buyer's agent and selling agent myself. So we're going to split that 3% on either side. If the property should go off the market, if you should change your mind, and we showed the house while it was under agreement and somebody came with an agent, looked at the house, and you took it off the market and a week later they came back and said, oh, I really love your house, I want to get that from you, and then you decided to sell it to them, at that point we would still be owed a commission because it was shown, and we say we're responsible for bringing that buyer, and so up to 90 days after bringing those buyers during that period of time, we would be looking for commission and payment for bringing those buyers if you should sell after that. Hopefully that's not the case, but sometimes things like that do come up. Other things out there, compensation to the brokerage, as I discussed, we're going to give the buyer agency 3% of this deal, and the rest of it, we're not going to entertain a transaction broker or a sub-agency out there. That's nothing we need to worry with. Earnest money is going to be held by the attorney. If there's any issues or discrepancy, if somebody backs out of the deal, this paragraph basically says that the attorney could take some of his fees out of that earnest money deposit before it's returned to whomever is rightfully owed that earnest money deposit. If there's any sort of dispute, you would potentially go off to mediation if there's any type of discrepancy as who's entitled to it if you were to fall out of contract for some reason. This one also says number 5 is signs. We did discuss that a little bit about signs, and you have the ability to say you don't want them on the property. In this case, we're leaving it in there because I think you said it was going to be all right. It outlines the broker's duty to bring buyers for you and what our limitations are for, I don't know, if for instance we're in your home and somebody breaks your $1 million vase out there, the liability limitation is to whatever the compensation is for commission. That's as far as you can come after me for something that would be broken, unless somebody has purposely damaged something on your property or something like that, or I would have personally damaged it. So it goes over a little bit of the liability there. Talks about the owner's duties and responsibilities to make the property available for showings and inspections. Also talks about if anybody approaches you about the house, please refer them to me for more details rather than getting into things themselves or showing the house without going through showing services and things like that. So please take a few minutes and review that information as well. Photographs, if we pay for them, are the property of the broker. Like I says, you're going to be able to convey marketable title. I think that's correct. You authorize the attorneys as settlement agents to go ahead and disperse fees as necessary. And again, number K is you're not going to deal directly with other buyers out there on your own behalf. And L, you authorize the broker in response to inquiries from buyers and other brokers to let them know that there are other offers if we're in a multiple offer situation. And quite frankly, you want them to know that because you want them to be motivated to offer as much as they possibly can in that situation. Number 9, the property's disclosure statement. So we want you to acknowledge any defects that you're aware of on the property, and we're going to provide it. I have already provided you with the property disclosure form, and as I said, if you're aware of any defects you plan or you have no plans whatsoever to repair, you need to make the buyer aware of that. If there are things as you're making these preparations in the next couple of weeks that you do plan on fixing or taking care of, you don't necessarily need to list those. But when it comes to showing out there, and a buyer is coming up, they need to know. Otherwise, you're being presumed to be deceitful if you're not disclosing things like a leaking faucet or something like that at that time. So make sure that you're as honest and open as you can in those situations. Disclosure, the owner authorizes the broker to disclose information about the property to other broker agents. So anything that we're aware of as a broker that's a material fact about the property, we do need to disclose and make them aware of. Unless there's something out there you don't want them to know that is not necessarily a material fact, and we can discuss those kinds of things. Taxes, the owner agrees to comply with the provisions of South Carolina regarding withholding requirements of owners who are not residents of South Carolina as defined by the state statute. So there are rollback taxes. I don't think any of that's going to apply here, so we're good there. Coastal tidelands and wetlands, not anything that we deal with here because we're not on the coast. Multiple listing service out there is something that we use, the MLS. So we want to get your property out there in front of as many people and on the internet if we can, so that as many people are looking at it as possible. So this basically says that you're giving us the authority to go ahead and place that on the MLS. If for some reason you do not want your property listed on the MLS, you would need to check option number 2 here. We are also going to be putting a lockbox on your property. We use a super lockbox, which is a special key that only real estate agents and home inspectors and appraisers, that sort of person, has the authority and ability to access your home. Every time that key is dropped out of that box, we know who has done it or have the ability to find out and why. So we want to be as safe as we possibly can and put that lockbox out there. So this is check saying that you agree that we're going to use that safety box out there for access to your property. Other offers, we need you to understand that we will present every offer that is given on the property. We're not going to withhold anything from you right up until the minute it closes. If there's an offer out there, we're going to present it for you. We're going to market the property as long as you want. If you're under contract and you don't want us to market it anymore, we will mark it as no show, so that no one continues to come through the house once we're under contract. The broker's compensation for services rendered in respect to any listing is solely the matter of negotiation between the broker and the owner. So I did mention to you, we have things that we consider to be norms, and I say that because if you see anything a whole lot less than that, the agent themselves might not be so motivated to bring a buyer to the house if it means a lower paycheck for them. But everything is negotiable, and I hope I've made that clear. And whatever the commission is, you're welcome to propose it. And of course, if I'm happy to work for that amount of money, that's the case. And we've already negotiated that out, but I just want to make sure that you're aware of that as well. Of course, maintenance, you will want to maintain the property, making it look as good as you possibly can for the duration that it's on the market. When a buyer is found for the property, the owner will sign the contract, and then the examination of the title work and everything will begin. Proration of taxes will be prepared by the attorney for all the property expenses that are involved in the transaction. Lead-based paint, we don't have that because your property is newer than 1978. Mediation clause, I mentioned that. If there should be an issue, it would go off to mediation. Fair Housing Act says that the owner and a broker agree that we're going to offer this property to everybody regardless of their race, their color, or any other protected classes, etc. And I think that's, for the most part, the most important things there. We're not checking for sex offenders, or criminals, or anything like that. So that's something that everybody has to do for themselves if they want to. Surveillance is one I want to talk about quickly. If audio and video surveillance of the property, please be aware of the fact that, anywhere that you would have expectation of privacy, like the restrooms and things like that, there should be no surveillance. We have Ring cameras these days that can record and do videos of people at the front door. So that's something that we just kind of need to be aware of. In some cases, if there's any audio out there, it's sometimes something that we need to disclose to people that they are being recorded. And if there's any other terms and conditions, like in this case, the security system of the property is Comporium and is not included with the home, I'm going to go ahead and put that out there because that is something that sometimes does convey with the property. Anything else of that nature that you don't want to go with the property needs to be listed so that everybody's aware of that. Other than that, you'll just sign the agreement in the particular places that you're designated to, and that should be the end of that.